Hi, I'm Jim Ruane, and I've been in the criminal court since 1972, and I'm here today to speak with you about how criminal cases proceed in the Connecticut courts, from arrest all the way through to a jury verdict in the case. So you've been arrested. Now what happens? If you were arrested and there was not an arrest warrant, the police must have probable cause to believe that a crime occurred and that you committed it. Upon your arrest, the police will take you to the police station and then they will set a bond amount. If you make that bond, that is, if you post the bond that the police have indicated, you will then be given a court date about 2 weeks ahead and released. It does take some time for processing because at the police station, they will take your fingerprints, mugshot, so it's not a very quick thing, but eventually, if you post the bond or if they release you on your written promise to appear, then you will be able to go out of the door of the police station. If you don't make bond, that is, if you don't post that bond by 7 a.m. on the next day, you will be taken to court, where the court will set a financial and other conditions of release. That proceeding on the next day takes quite a bit of time, and so don't expect it to be very fast. If you fail to post bond, the judge must decide if there is enough evidence that the state has a case against you. This is based upon a Supreme Court case from the 1970s called Gerstein versus Pleas, which held that there must be some judicial finding of enough evidence to set a bond and hold you in custody. While in custody, the bail commissioner, who is an officer of the court, will interview you and review your arrest record, if any, and your ties to the community, and then make a recommendation to the judge as to what the bail amount should be. He or she will tell the judge if you have any prior convictions, if you have done any jail time, or if you have failed to appear on any prior case. If you are arrested with an arrest warrant, there are supporting affidavits to make the case. That is, the police create an affidavit and submit it to the judge that indicates why they believe a crime occurred and why they believe you committed it. A warrant affidavit is filed in the clerk's office, and it is available to the public unless the judge has sealed it, but that sealing usually is for only 2 weeks. Now, the judge can set a bond on an arrest warrant or leave it to the police. If the bond is set by the judge, that amount has to be posted with the police department or you will not be released. The police cannot reduce a bond set by a judge. Only when a judge has your case on arraignment can that bond be modified. If you don't make bond, your presentment is the very next business day. A written promise to appear, which can be entered in your case, is a release on your own recognizance. But the judge can also set conditions of release, even if you're released on your own recognizance. For example, to get an anger management course going, or to not go near a victim or a place where a crime occurred. And if it is a family case, the court can enter a protective order. This is a specific court order, and it can keep you from going back to your home, except one time in the presence of police officers to get your items of personal nature. It can order you to stay away from your house, your spouse, or your children until such time that it is modified by the judge. And if you fail to comply with this kind of order, that is a very separate crime. Now, let's talk about arraignments. An arraignment is the term used for an early appearance before the judge when you enter a plea of guilty or not guilty to the charges. When you enter a not guilty plea, the defendant elects a court trial or a jury trial. Now, a court trial is a trial where a judge hears all the evidence and the judge decides whether you are guilty or not guilty of the offense. A jury trial is when a jury is impaneled and the jury decides guilty or not guilty. Remember that all the jurors must agree on the verdict. If the jury cannot unanimously agree on a verdict, then the jury is what we call hung. And a hung jury really legally means that a mistrial is entered, and the case is set down in the future for a retrial of the case. Now, after pleas of guilty or not guilty, there are proceedings that will result in alternative dispositions to the case. Starting in the 1970s, the Connecticut legislature set up different programs that divert cases from the narrow trial or jail track to a series of programs that require the accused to do certain things in order to obtain an eventual dropping of the charges. These are called diversionary programs, and they are tailored to the crimes that are alleged. Here are some examples. Impaired driving. The Impaired Driving Program is for people arrested for driving under the influence. If the person completes the program, alcohol counseling required, the case can be dropped and it will never amount to a conviction for driving under the influence. Accelerated Rehabilitation is the original diversionary program, and it applies to all but the most serious offenses. The court can impose conditions to this program that are adaptable to the case. In order to obtain this program, you must give the victim of the offense notice of your application so that the victim can come to court and object to the court granting the program. Now, Accelerated Rehabilitation is basically a non-reporting probation. You are placed on probation for up to 2 years. If you get arrested again on a charge, you will be removed from the program. The maximum length of the program, as I say, is 2 years, but failure to complete the program satisfactorily leads to your case being restored to the trial docket. There are other programs similar to these programs that are based on the underlying charges but can provide for the chance to obtain a dismissal of the charges. The Drug Education and Community Service Program, that is obviously for drug possession offenses. The School Violence Prevention Program, based upon violence or violent acts in a school setting. Or the Supervised Diversionary Program, which is for people who are veterans or have an underlying mental illness. The Gun Violence Program, for those who were charged with the possession of a firearm. Once the not guilty plea enters, discovery then starts. Let's talk about discovery, because you may have heard that term before. That's when your lawyer requests that the state provide the defense with all the police reports, scientific reports, photo arrays, fingerprint cards, and anything else that will be of help to the defense. The state has a duty to provide all mitigating evidence, and that means that all evidence that would show that you did not commit the crime, or all evidence would show mitigation, that is, to lessen your guilt, even if it does not fully exonerate you. Your lawyer can file legal claims in an attempt to limit the state's evidence against you. This is done by a motion asking the court to prohibit the evidence. Some usual topics are the following: suppressing an identification because it was suggested by the police, suppressing any evidence seized from you, your person, your house, or your car, limiting any evidence that you committed any other crimes in the past, limiting expert testimony because the expert's report does not establish the scientific reliability of the test in issue. Your lawyer can also ask the judge to have evidence tested because the result may help the defense. Now, you may also hear the term pretrial used frequently by the lawyers and the judge in the case. A pretrial is the generic term used to describe all the court appearances after the arraignment and prior to a trial or prior to a plea of guilty. In Connecticut, judges participate in discussions of the case with your lawyer and the state's attorney on the case, with the hope that a resolution of the case can be had. A judge who is involved in these discussions cannot be the judge who would preside if the case went to trial. At the pretrial, the discussion often concerns the following issues: whether there is enough evidence to have a trial, the opinion of the victim, who has expressed that opinion to the victim advocate, whether the charges meet the evidence or should be reduced to charges that are more appropriate for the facts of the case, the possible minimum and maximum sentences for the crimes, the mental state of the defendant, and whether he or she had the mental state that is required for the crimes alleged, whether the penalty should be a jail sentence, a combination sentence of jail time and then probation thereafter, a period of probation only, or any unique questions of law that arise in the case. Now let's speak about pleas of guilty. If a person decides not to challenge the arrest and risk a heavy sentence if he loses trial, the defendant can agree to plead guilty for a definite penalty. Now, a misdemeanor offense is one that carries no more than 1 year in jail. A felony is any charge that calls for a penalty in excess of 1 year in jail. This is called the plea agreement and sets forth the following: the exact charge with the statutory section noted, the plea of guilty or nolo contendere, which just means a plea of no contest, the exact penalty to be imposed. If multiple penalties are involved, they're stated to be either running concurrently, that means running together, to any existing penalty, or consecutive, which means they start only when a prior sentence is completed. Acknowledgement by the defendant that he or she agrees to the disposition of the case. Acknowledgement by the defendant that he or she understands the waiver of his or her constitutional rights not to incriminate himself, to challenge the evidence against himself, to testify in his own defense, and to bring in other witnesses to prove that he is not guilty. An acknowledgement that if he agrees to the plea, he will not be able to withdraw the plea unless the judge permits him to. Acknowledgement that a felony conviction can bar him from voting or having a gun permit, or, if required by statute, acknowledgement that the sentence cannot be suspended or reduced. Acknowledgement that he is satisfied with the representation that his lawyer has given him or her. An acknowledgement that the plea may cause the person to be deported. Now, let's talk about trial. Trial by the court means, as I said, the judge presiding over the case, hearing the evidence, and deciding if the state has proven all the elements of the crime beyond a reasonable doubt. If so, he convicts the defendant. If he finds the evidence does not prove the charge, then he acquits the defendant. That is, he finds the defendant not guilty. A trial by jury is where the jury hears all the evidence and the judge instructs the jury on the applicable law, the legal principles of the presumption of innocence, and the requirement that the evidence be beyond a reasonable doubt. He or she will explain the elements of the offense and the test for determining what is proof beyond a reasonable doubt. All elements of the offense must be proven beyond a reasonable doubt. Trial occurs in this order. First, the prosecutor and the defense lawyer give an opening statement identifying the witnesses to be called and the names of the lawyers the prosecutor or defense lawyer has in his office, in case a juror might know someone that is named. Second, the defense does the same and can highlight for the attention of the jury an issue that helps the defense. For example, saying, "I'm going to ask you if you have any bias for or against scientific evidence or police officer testimony." Thirdly, the judge gives an instruction which is an overview of the legal principles in a criminal case and the timing of the trial. The judge then asks the jurors to indicate if the timing or the nature of the case or the names mentioned would cause the juror to have any problem in being fair. The judge then can excuse any juror who has indicated a problem. Fourthly, then and only then, the jury selection actually commences. The parties alternate in questioning of the jurors. For example, the state goes first and the defense goes second. On the very next juror, the defense goes first and the state goes second. Now, at that point, the state and defense can each challenge a juror if they believe there is cause to question the ability of the juror to be fair. Each side can excuse up to 8 jurors, 6 for the regular panel and 2 for the alternate jurors. Jurors cannot even be asked why they were challenged. Sometimes through questioning, it can become apparent that a juror has some problem, and in that case, the lawyer can ask the judge to excuse the juror for cause. If that occurs, the challenge is not counted against the lawyer's 8 challenges. Challenges are usually made after the juror steps out of the courtroom, although older judges have been known to make the lawyer state a challenge while the juror is still on the witness stand. Now, the order of presentation of a trial goes this way. The state's case goes first because the state has the burden of proof. The state's witnesses are called first until the state's run out of witnesses. Each witness can be cross-examined by the defense, although the defense can decide not to cross-examine if the testimony would not add anything to the case. When the state finishes with its witnesses, the state announces, "The state rests, Your Honor." At this point, the defense can move for an acquittal, claiming that the state failed to prove enough evidence to warrant a jury to decide the case. The judge can then deny that motion or grant it and enter an acquittal in favor of the defendant. Then it shifts to the defense case. The defense has the right to call witnesses in support of the defense, and the state has the same right to cross-examine these witnesses as well. The defendant has the right to testify, and the judge usually, in the absence of the jury, asks the defense if the defendant will testify. If the defendant wants to testify, he does so like any other witness. If he decides not to testify, in the absence of the jury, the judge will address him directly and get his response. This is done usually to prevent the defendant claiming, if he loses the trial, that he was prevented from testifying. Once the defense calls all of his or her witnesses, the defendant announces to the judge, "The defense rests." At this point, the defense can again move for an acquittal because there is not enough evidence to warrant a judge to decide the case. That, however, is a rare occasion. There's also something known as the rebuttal case. After the defense rests its case, the state can present evidence that rebuts what the defense witnesses have said. This is called a rebuttal case and is limited to the issue which rebuts the defense claim. For example, the defense may call a witness that testifies that the defendant was elsewhere at the time of the crime. So too, the defense can call a rebuttal witness to rebut what the state's rebuttal witnesses have said. Again, this is specifically limited to the issue that's being rebutted. For example, a state may call a witness who testifies that the defendant is wrong because the witness could not have been in a position to see the defendant commit the crime. The defense can call a witness to establish that the defense witness had ample opportunity to see, and therefore this rebuts the state's rebuttal witness. Once all rebuttal witnesses are heard, the judge declares the evidence completed and instructs the lawyers to sum up their cases. Now, summation. Connecticut law limits the state and the defense to only 1 hour for summation. Because the state has the burden of proof, the state gets 2 chances to address the jury, while the defense has only a single opportunity. But the state must use its 1 hour to cover not only the state's opening summation, but also its rebuttal summation. The state goes first and usually repeats the evidence that shows that the defendant committed the crime, but it may limit its summation to a bare minimum so that it will have more time to rebut what the defense summation says. Then the defendant sets forth its summation. It argues why the evidence does not meet the standard that the state offered. It may also argue what it proved in its rebuttal summation. Then the state has the opportunity to rebut the defense summation. Following this stage, the judge then proceeds to his and her instructions on the law. Following the close of the evidence and the summations of the parties, the judge will read to the jurors the jury instructions. Often the judge will have them printed out so that the jurors can follow along with the explanation. The instructions have a number of parts, such as these: legal principles, such as proof beyond a reasonable doubt, presumption of innocence, how to judge credibility of witnesses, the requirement of each element proven beyond a reasonable doubt, the requirement of a unanimous decision by the jury, the specific charges alleged, and the statutory definitions of the elements, as well as the definition of certain elements of the offense. The requirement that the decision is made by each juror and not just agreeing with other jurors in order to finish up the trial. That a verdict must be unanimous, and the procedure to use if the jury wants to ask the judge any question about the charges or wants the testimony to be read back to the jury, or how to report that a verdict has been reached. Now, reporting the verdict. The jury sends out a note that it has reached a verdict. The judge assembles the court, the parties, and the jury. The clerk does a roll call of the jury, and each juror stands. The alternate jurors are dismissed, and they are advised that they should remain nearby if the judge wants to speak with them after court recesses. Then the foreman announces the verdict verbally. The clerk asks the other jurors if they agree with the verdict, and the jurors respond verbally. At this point, either party can ask for the jury to be polled. This means that the clerk asks each individual juror if that is their verdict. The judge accepts the verdict and instructs the clerk to record the verdict. Then the jury is sent back into the jury room. If the verdict is not guilty, the defense moves the court to discharge the defendant. If the verdict is guilty, the court sets a sentencing date. Usually, the state asks for an increase of the bond amount since the presumption of innocence is erased. Then, the court is adjourned. Often, the judge speaks to the jurors and answers any questions that they have back in the jury room. And that's it. That's your case from arrest to verdict and hopefully dismissal. If you want to learn more, please visit RuaneAttorneys.com. Or if you find yourself in legal trouble, give us a call at 203-925-9200.